The moral of that story is she ended up subscribing to an AI platform and used that as essentially her counsel, right? So she typed in different prompts and got a lot of information about different resources, how to structure her arguments that failed in the past, but arguments that might be successful for her specific case. And she went into court with those arguments, with those links to different resources, and ended up winning, right? So she won significantly.
I'm Hal Marcus.
And I'm Memme Onwudiwe.
And this is Meeting of the Minds, the legal AI podcast from Evisort.
We interview lawyers, professors, and legal operations pioneers that are pushing the envelope.
Leaders using technology to drive great business outcomes and shape the future of the profession. Memme, happy near end of year. This is going to be our last episode of 2025.
Yeah, and we're going out with a bang. Today we chatted with Kimberley Odums. She is a senior counsel of intellectual property and artificial intelligence at the IEEE, which stands for the Institute of Electrical and Electronics Engineers. And she's also the founder of the newsletter and community Lawyers Learn AI.
Yeah, and IEEE is not for people of my vintage, just like the manufacturer of cables for the internet. They're a standards organization, whole other thing. Anyway, we had a fascinating conversation with Kimberley. I really like her newsletter, Lawyers Learn AI. I think maybe there should be punctuation in it. Lawyers, learn AI, lawyers learn AI, exclamation point. But regardless, it's a great newsletter with very practical advice, lots of information just about what's happening in the present day. And we had a really interesting conversation with her, a little bit different for a lot of what we tend to focus on here, is a little less about the impact of AI on the profession and on the law, and really a little more about the impact of the law on AI.
Yeah, I mean, we talked about a lot of the incredible court cases happening in the world today, which are affecting whether or not and how big AI companies are able to actually use the data they take from the internet and from other places and build their algorithms. And a lot of these questions, have not yet been answered, but I think it was mentioned that there's over 250 different kinds of AI copyright cases from companies from Anthropic to OpenAI to Mette. And so just delving into that landscape, I think was really interesting. And Kimberley also had great advice for lawyers looking to take their careers in a more of an AI direction in the way that she has.
All right, well, let's jump right in.
Kimberley Odums, thank you so much for joining us today on Meeting of the Minds.
Thank you both for having me. I'm really excited to be here and to have this discussion.
So, Kimberley, you've had a really interesting and somewhat unusual career path in terms of how you've delved into AI and the different roles you've had. Tell us a little bit about how you got started.
Years and years ago, I graduated law school, and I went to a small school in Springfield, Massachusetts. After that, I worked for a regional firm there and really got my feet wet as a baby lawyer, learning the ropes, trying to figure things out. From there, I was recruited to a larger firm in Boston. So I ended up moving to Boston and working for the labor and employment practice of an international firm there. So I worked there for a time. And then, big law is a little challenging. If you've seen any shows like Suits or any of the top movies, they're usually talking about big law. So very
documentaries, right? Those.
Yeah,
yeah,
absolutely. Very intense, very, high stress. So I did my time there, got the training that, a lot of lawyers do. They put their time in. And then I went in-house to a nonprofit and really enjoyed that work. I'm very mission driven. So the mission of the organizations that I worked for kind of spoke to me. And then I got sick of corporate America. I just was over it. Even though I was doing good, it's the bureaucracy, the red tape, having the desire to do good, but then being stopped and not being able to do the good work was really, really frustrating. And this was right around the time of the pandemic. So I ended up leaving corporate America. It kind of aligned with the fact that I was just having my first child. So I was home, pregnant, still wanted to kind of, use my brain. Because again, it's the midst of the pandemic, nothing's happening. So I ended up starting my own law firm. So I, after I had my child, I with my baby all day. And then at night when hopefully she slept, I was, crafting emails, scheduling them to go out the next day, sending messages and the like. So I ended up starting my own law firm and ran that for a number of years, trademark and brand protection work, because trademarks is such a unicorn practice. Once you understand it and once you can do it, it's federal. So I can have clients from California to Texas to Maine to Florida, all from the confines of my home, right? So it was a practice that made sense for where I was in life. And I did that. I enjoyed it. And then one day I was on LinkedIn and I got a message from a recruiter. They said, we see what you're doing and there's a job opening at this tiny company in New York. You've probably never heard of it, but they need someone for a 6-month stint potentially to help with contracts. It's year end. They have a lot of contracts that they need to review and approve. Are you open to it? So I ended up, I asked them what the company was and they said, oh, it's called IEEE. I'd never heard of it before. And I ended up starting there. It's supposed to be, again, a 3 to maybe 6 month stint. And they made me fall in love with the work again and the people. And from that, long story short, the general counsel heard about my efforts, asked me to come on full time. And then I heard about this thing called ChatGPT and I was curious. So I went online and it was the first iteration and I typed in what I now know to be a prompt and I got what I now know to be the output. And I was blown away because, again, any lawyer, anyone really, the first time using ChatGPT does kind of blow your mind because, inputting a prompt and getting a full document, a full analysis, a full anything. Whereas I used to spend hours, weeks, crafting the perfect, motion, the perfect contract. And here was a tool that was allowing me to do that in mere seconds. Granted, you have to go through, improve, iterate, but you have a fantastic first draft. So I was blown away immediately. I brought that back to my contracts team. I said, have you heard about this thing? They said no. I said, let's screen share so I can show you. So I definitely showed them and, they were impressed, but I just ran with it. So I researched, I was reading about the different articles. As we know, ChatGPT was one of the most downloaded applications and most used at most user signups, I think, ever at the time. I think it may have been surpassed by things out. Yeah. But it was so groundbreaking. People are comparing it to like pre-internet, like there's before the internet and then the internet. So there's like before ChatGPT and after ChatGPT. It's one of those monumental moments that people, refer to. So, I leaned into it again and, used it and kind of played around with it. And then I thought about how it would change everything, right? So I knew the company that I'm a temp for right now. They had a huge publications arm, and having an IP background, I know what copyright means and I know what it meant to AI. Even though I was figuring it out, I knew these models were trained on human authored works, right? And I just knew what the implications were. And again, I'm consuming a lot of information as far as articles and whatever people were writing about the technology. And I crafted it together, crafted a presentation, took it to my GC. And I said, look, I'm supposed to be doing contracts. That's fine. I'm doing great over there. However, there's this technology that I believe will impact this organization. This is how I believe it will impact the organization. This is what I think we need to look out for. These are the stories in the news that should shake us because, other companies are already getting caught up with data leaks, et cetera. So I just think it's something to watch. And if you're open to it, may I watch it and just report back to you? And she was thrilled. She said, yes, thank you for bringing this to me. So from there, I ended up, doing a presentation with our GC to our big management board. They were pleased with, what we were presenting. And from there, I just kept tracking it. And ultimately, I was elevated again, I think several months later. Well, she hired me full time. And then I believe 7 months later, I was promoted to, from temp to contracts attorney to senior counsel responsible for global IP and AI. So that's how I got into my role, by just seeing what was happening and being really, really curious. And then, doing the scary thing of saying, hey, I just want to tell you about this thing that's happening.
So if you can share, what were some of those implications? That's interesting that your fascination with the tracking the news of the day around AI, which we'll get to in your newsletter shortly, that actually emerged then from your work. What were some of those implications for IEEE?
Yeah. So very early on, so one, because I do have the IP background, I knew these model, they're answering the model itself. Let's focus on ChatGPT, for example. I could type in a prompt about tomatoes and they know everything about tomatoes, or opera, they know everything about opera, or submarines, they know everything about submarines, right? I'm getting an input, an output, and I'm asking it not just singular questions, right? This is not a platform to ask questions about animals, right? Where it's like, all right, maybe they just trained it on animals. This platform is providing me with an answer about any question that I ask. How is that possible? So I started researching and understanding what AI was. And I'm very much a sci-fi nerdy lady. So like Skynet, I think it's coming. I've always thought it was coming. But, you know,
My
I've just
name's
always,
Hal, so you must already be
yeah.
uncomfortable talking to me.
Yeah, so I've always had like that fascination. I used to watch The Outer Limits, Star Trek, all that stuff as a kid. Love it. Still watch it. So I was always like fascinated, like, oh, this is new, but it's not new. They've been talking about this for a very long time. So I started researching. I realized like AI as artificial intelligence, sorry, as a concept is not new. The term was coined in 1957. There was a conference held, what is the University up in New Hampshire? Dartmouth, where a lot of folks came together, and the entire focus of the conference was creating, I'm going to butcher it, but essentially creating a technology that could mimic like human behavior, or could outsmart, or could do essentially what a human could do. So 1957 is when that big conference happened. And since then they've had what they call AI, like summers and winters, right? So a lot of interest and then it dies out. A lot of interest and then it dies out. And then with ChatGPT, here we are with the summer again, right? It's spiked. There's a lot of interest, and we're still kind of riding that wave, even though folks are now saying AI is a bubble. But that's another discussion. But yeah, I just researched what AI was, and then like, how do you train a model? And I realized, and it became pretty obvious and open, that ChatGPT is what it is because OpenAI scraped the entire internet and just pulled all the information in and used it to train their model. So that's why, you know, that blog you wrote about plants, like that's been scraped and that's been used to train it. So now
They
when someone
scraped
goes
my
and
blog about
they
plants.
scraped everything, yours specifically, yes, they did. So yeah, that's how ChatGPT and other models, that's how they are what they are. That's how they become what they become. Because very early on, when no one was really, I wouldn't say paying attention, but no one knew to pay attention to this, they just went out, scraped, used it to train their models. And now we have these great tools, right? I am an advocate for AI. I use it every day, but two things can be true at once, which is AI is a great tool, but at what cost, right? So that's why we have a lot of these lawsuits, and we'll get into those. But, you know, folks are saying you're using my work to create this product that maybe it's not profitable now, but it's worth something, right? So compensate us accordingly. And right now they're saying no, like this is what's necessary for the advancement of the technology for us to be able to have essentially free reign on content. So yeah. So to answer your question, which I don't think I did, I saw that and I researched that, and I knew as an academic publisher, like our information is very valuable. So at our organization, you know, we're selling subscriptions so people have access to this content. And if for some reason this content was able to be just uploaded into a model and someone can go to ChatGPT instead of coming to us, why would they pay what they pay to subscribe to our content behind a firewall when you can just sign up for ChatGPT and get the information for free? So I saw that, presented it. Luckily, folks saw that as well and they agreed. And here I am tracking all these years later.
Wow. And, you know, I would love for you to talk a little bit about, you know, the role of IEEE, you know, especially the fact it's a massive organization from the amount of people who are involved with it, you know, engineers from all over, which,
Yeah.
you know, actually has implications as it pertains to AI development as you kind of work with software engineers, you know,
Yeah.
focused on AI. For folks who don't know about the IEEE, maybe they haven't used those internet cables and such. You know,
They
what's
use
could you
them.
talk
They just don't know what they're called.
Great. So yeah, IEEE is the biggest like secret you've never heard about, but impacts, you know, our lives. And I'm not speaking on behalf of the organization. I just happen to work there and these are my independent thoughts. But yeah, the organization, again, love working here. It's been, again, it pulled me back into, you know, corporate America. So the organization is a very old organization. believe we just celebrated 125 years. And before I joined, I knew nothing about it. But if you're an engineer, you have an engineering background, there's a high probability that you know about the organization, because our entire mission, though we are a nonprofit, our membership base is engineers, roboticists, technologists, folks who build tech, folks who are interested in, again, like robotics. We have a lot of societies, the computer society, like just different things, different collections of folks who are in the engineering and tech space. And, as an organization, we are a standards organization as well, meaning we develop standards. What are standards? So standards are, I would say, internationally accepted parameters for a thing. For example, we own the standards for Wi-Fi, right? So collectively, a group of international thought partners got together and they created the standards for what Wi-Fi is. So you have to meet these preset rules for the thing to be considered Wi-Fi. We also own the standards for pacemakers, I believe. So pacemakers, they have to adhere to these set of rules in order to be, considered a pacemaker or identified as a pacemaker, et cetera. So I work with the standards organization as needed, but they're so complex, they're so specialized. I'm not going to speak more on them because I don't want to get it wrong, but that's essentially what a standards organization is.
So as you look at all those IP implications for AI, how does that affect you in your daily life at IEEE?
So as a practitioner in this space, what I've seen and what, my colleagues are seeing is, first and foremost, when you're working in-house, you represent the organization, right? So you are tasked with kind of figuring out how to protect the organization. In my case, I'm tasked with figuring out how to protect the organization, its data, its content. We don't want leaks. We want to keep the organization safe. So what I do, what other colleagues do is, for example, I'm a part of the AI governance team at my organization, right? So that started out myself, members of IT, and it was a way for us to just kind of get together and brainstorm what's happening and figure out, like, we have employees asking to use AI. Like, what do we do, right? So that has morphed into a full-blown AI governance council, cross-functional, right? So we pulled in representatives from our business teams, a lot of IT folks, because they know the data security, they know all of the technical things that needs to happen to kind of wall us off against improper use of AI, for example. But what I see is, one, there needs to be education. Well, first, there needs to be communication. So initially what our organization did is say, hey, we know that there's this thing called AI. We know that you want to use this thing called AI. But perhaps right now we don't have enough information about its implications. No one does. It's brand new. So we're going to put a pause on it. So for a time, we put a complete moratorium on AI use, right? We're going to wait and see and get more information. And we did that. We went out in the industry. We saw what others were doing. There are lots of conversations, many of them above me, right, with other organizations to kind of see what they were doing and how they were handling this. And again, we are a publisher as well. So lawsuits that were happening, we're seeing, publishers are suing these companies. Like, is it safe for us to use it? So, we were very vigilant. We kept a close eye and a close watch on what was happening in industry and just in the world at large. We communicated with our staff and said, hey, whenever there were updates, there were updates. Now we've kind of shifted away from that now that we've had time and we have more information. So it's not you cannot use AI. And I always say, as legal, I'm not the department of no. I'm the department of yes, but. Yes, you can do this, but this is how you should do it, or this is the recommendation. So the organization is
better than the department of it depends.
Yeah. Oh my goodness, it depends. But yeah, we've shifted into understanding that AI is not going away. We know that folks are using it. This is how you can do it safely, which I always advocate for, creating a safe sandbox space, for example, for folks to kind of test and dabble with AI safely. Because even outside of my organization, I always say folks are using it anyway, right? There's was it BYO AI, bring your own AI? You can tell folks that, no, you cannot use it. You can even block it on your network, right? Folks have phones. You can they're using it, right? So it's like you can't take the salt out the soup. Once people know that this thing exists and they've used it, they're going to use it if they believe it can make them more efficient, if they believe that it can help them complete a task faster.
So on that point, more and more organizations and enterprises that have AI governance councils and try to strategize company-wide have secured licenses to individual LLMs, multiple LLMs, certainly lots of applications, ours included, that leverage, LLMs. So what have you seen in terms of that improving the ability to empower employees with the technology in more of a secure way? Has that been a good path? Does that quiet down the use of bring your own AI?
So yes and no. It depends. That was such an it depends answer. Yes
Yes or
and no.
no is not, it depends. That's a whole other thing.
So
You're
I'll
good.
go broad and then I'll go narrow. So broadly, and I've done like a few speaking engagements here and there. What you'll find is there's a full spectrum, right? You have the AI zealots, the advocates, it's going to replace everyone. I won't need any employees. I'll just need an AI. And now I'll just need an agentic AI. Like you'll have that spectrum. And then you'll have the folks who are just beyond weary. They won't even engage with the technology, right? For whatever reason, there's an apprehension there. I think the majority of people fall squarely in the middle where they're curious. They'll dabble, but they're not using it every day. They'll use it, like Google, even though I have rules against that. Google's for Google. AI is not for that, right? But they'll use it in the same way they use Google. They understand it. They think it's cool, but they don't quite know how to incorporate it into their work or their life in a meaningful way. So because you now have that very broad framing, right? In practice, there are enterprise tools, for example, right? So Copilot is Microsoft Copilot is an AI tool, and it's embedded into like the 365 suite. So you can't even turn it off at this point. It's in Word, it's in Excel, so people can use it. And it's become the leading tool because it's incorporated into Word. Everyone uses Word. You've used Word forever, right? So it's incorporated into that tool, and it passes a lot of the IT assessments and security prevention mechanisms. So what you have currently is an industry where that's kind of the go-to for a lot of organizations. It's safe and it's in a tool that people are already familiar with, Word. So then that sets the stage for, hey, people may want to use this tool, and that's where they can safely test out, right? You're not going now to ChatGPT or Claude. You're just opening Word, and then Copilot is there, and you're testing it. So I think that they put themselves in a great position because a lot of enterprises that would otherwise say no can't say no to this because it's embedded, right?
Yeah.
Then from there still needs to be the educational piece because a lot of people don't know how to use AI. So I think the next frontier, the next wave of things that we'll see is a lot of like, and I see them now. I could rattle off X amount of like AI training companies or AI training platforms, right? But it's around the educational piece. How do you use this, and how do you use this in a meaningful and purposeful way? Because a lot of people still don't know. And I hope I answered your question.
Do you think we're evolving, though, to the point where on that last piece about the education, where a lot of it is almost going to become moot because the conversational experience, you mentioned Copilot, the conversational experience with AI, I think a lot of people look at it as almost a panacea, like that's
Cure-all. Fixes everything.
Everything, right?
Yep.
It's more of a portal because all sorts of things can connect with Copilot. And Copilot may be your way of getting to that thing, but the ultimate implications of where is that data going? What is it enabling? What is it searching? How reliable is the result? All of those things are still relevant, even if the answer is being delivered to you indirectly through Copilot.
The educational piece will always be relevant, right? Because we went from here's ChatGPT to here are 500 other AI tools to folks don't know how to use it to now it's embedded in these enterprise tools. So you kind of have to use it because it's there. You don't have to use it, but it's running in the background. You're going to be curious. To now we have agentic AI, which is like the next level up. And it's like, if you don't know the basics of how to use what's now, the baseline tools, getting into agentic AI and saying, oh, well, this will log into your Gmail and it'll calendar stuff for you. And it'll also buy your plane tickets and do all that. that will get everyone caught up in the worst way possible, because that giving access to your life to an AI tool that you don't understand cannot go well for anyone. And especially in the business context, we've seen folks give away trade secrets, in an effort to summarize a meeting, right? Upload this recording, please provide a summary. And now this made news. Like, now someone with the proper prompt can pull out, your beta testing for this new product that you're going to roll out, all for the sake of efficiency, because you didn't understand you cannot just upload things like that into a tool. So I think education will remain important, even if it's just simply saying these are things you should not do.
I mean, speaking of the importance of education, you're on the forefront of this, being that you founded Lawyers Learn AI, as a kind of an avenue to teaching lawyers about artificial intelligence and kind of how to use it through a community. Could you talk a little bit about what prompted you to do this?
So let me take a step back. Way back when, before I launched my law firm, my husband is like this very entrepreneurial minded person. And back then I was very much like, no, you go to school, you get a job, you work the job, you get the money. That's how things go. Very rigid, right? But he rubbed off on me in the best way possible. And I ended up starting a company called like Contracts with Kim. And I went online and was like, oh, I have a platform where you can buy contracts as a business owner, right? You don't need a lawyer per se. Here's a template contract. You can use it. And literally, once I made my first dollar, just my mind was blown. And it was just like, oh, you can do entrepreneurial things, right? You can do things outside of your 9 to 5. Because believe me, before then, I don't know why, but I had this very narrow view of things. So once that happened, my spidey sensors went off. And since then, I've just been looking for different avenues to like express myself or be creative or use what I know in a different way. So fast forward now, I would say literally about maybe 2 years ago, I realized I knew a lot more about AI than other people, but I didn't think people cared. In my mind, it's just like, well, everyone knows what I know, until I spoke to people and they're like, oh, you know so much. I'm like, oh, I thought everyone knew this. And that is a mindset and block that I need to get past, because I still think everyone knows what I know, until I talk to someone. They're like, oh, this is informative. So Lawyers Learn AI was born. I bought the domain like a year and a half ago. Like, it's been a thing, right? But I wanted to launch it out of, I would say, necessity, right? Because when I was starting, I was just fumbling through. And granted, I was aware, or I was curious enough to recognize ChatGPT and like pursue like that curiosity, but I kind of fumbled my way through. A lot of trial and error, a lot of having to keep up with different news sources. And as we know, AI, it changes immediately, right? So what was true a month ago may not be true currently, because things just advance so quickly. So I created this space as a community. Lawyers Learn AI is a community for AI curious lawyers and AI legal experts. They're kind of the two buckets, because, if you're curious, please lean in, and we're going to lean in with you and share the information. But then also there are folks who, again, have been involved in AI for a very long time. So in my view, you're an expert, right? Because you've just been doing it for so long that, yes, we would look to you for guidance. So it's primarily right now a newsletter. It goes out every Sunday, and I'll go through how I structure it. But the goal is to keep lawyers informed. It's to be a source that I needed when I was starting, which is someplace I could go to, one, reach out and ask someone questions, because I'm very, accessible by email, but also, a place to get like and this is how I structure it. It's like a quick note from me about what to expect in this week's newsletter. Then we do AI in AI news. So like the top legal cases or things that we're seeing. So recently we talked about landmark settlements on the AI space, folks being fined, lawyers specifically being fined for using AI hallucinated text in briefs and motions that they filed with the courts, and how the courts are handling that. And just other important news for lawyers to know about. And the goal there is I want them to be able to read that and go into their office Monday morning and share it with their team. I pitch it as, become the go-to AI legal expert on your team, right? So you'll have the information to do that. I then go into, we have an AI prompt library. So I have a practical AI prompt that you could utilize right now as you read it with any AI tool, whether it's ChatGPT, Copilot, et cetera. You can pop that prompt in and get an output that's useful for you. The other portion of it is just a practical tip. So something you can do within your organization to kind of, place yourself as someone who is in the know and who is tracking AI and who's helpful. And then I have other things that are brewing. So yeah, that's a general framing of it. And again, it's something that I think will be helpful for anyone really. Like if you're seasoned, and I have a number of people. So I was good with my sign up, I kind of track where you are professionally. Are you a dabbler? Like you're just beginning, you don't know anything about AI. Are you a practitioner? You kind of use it. Are you an expert? So I kind of track that so I can segment my audience. But I have a good mix of folks who are just starting out. Like I've heard about AI, but I don't use it because, I'm just nervous or I just haven't had the time. All the way up to, I speak on this regularly. I'm the chief legal AI officer at my organization and everyone in between. So it's a source to kind of get your information and find community around this very specific topic.
There's two things I want to ask you about there, and I'm going to ask them together. The first is, what are the themes that are then, as you get feedback, as you see the engagement with the newsletter, as you look at the topics of the day? Because I'm really struck at how you are looking very much at the topics of the day, not so much the 5 years down the line, Skynet, et cetera, kind of stuff. Maybe we'll get to that later. But so what are the topics that are jumping out most at you? And secondarily, you mentioned sharing prompts. This is an interesting area that I'm curious, what kind of reaction are you seeing there? Do you see that as an important theme for how adoption moves forward?
One of the big wins for me is that folks really, really enjoy just the news, AI news this week, right? Because I try to structure it on what happened in the past week. So it's very relevant and it's very timely. And a few people reached out. One person specifically reached out and said exactly what I just said, which is she was able to bring that back and speak to her team about it. And it was well received because, again, you are coming in on a Monday. Again, my newsletter goes up Sunday purposely so you can skim it, read it, and be ready for Monday. And she went in and she said, hey, I mentioned this to my team. I forget which store it was, but she mentioned it to her team and they were excited about it and wanted to know more. So that's a win for me. That's a feel good moment for me because you took something that, I thought about and I crafted, I summarized for you with links because we're lawyers. We always got to verify. So I put links to either the court docs or, a reputable news source so you can read more in depth about it. But I summarize it, package it, and now you have something to go into the week with. So that's the first part of your question. For the second part, the importance of prompts. Prompts, garbage in, garbage out, right? You need to structure your prompts accurately. And what I found over time is you kind of have the same formatting or framing of a prompt. And I don't want to have to sit each time and act as you are an experienced executive of 25 years, create a marketing, like I don't want to have to do that every single time. So I early on began creating what I guess we'd call the prompt library. And I label them. I'm very neurotic about that. I'm like, this is for the newsletter. This is for this. This is for this. This is for this. So that I can copy and paste but tweak as needed, right? I know I'm going to want a formatted newsletter every week. So that's not really going to change unless I'm doing something special, right? So when I go in each week but I also have a custom GPT. I have a bunch of things. But for folks who want to use like the prompts, I don't want you to have to start from scratch every time. Like you should have a baseline and building blocks, right? That you can copy this, add, create brackets where you add specific information for like a nuanced topic. And if the promise of AI is to save you time, I don't want you wasting time because you have to craft a prompt every single time. So I want you to have a building block that you can build off of.
In the spirit of arming folks with information that is, just practical around, what's going on in the world of AI. And, I hesitate a little bit for us to talk even generally about any of these kind of court cases happening, just because they are so much in flux. And this, of course, will be published, a few weeks after we've recorded. So, just a spoiler alert, much of what we talked about may be settled and may be in different phases. But, as we talk about AI, so much of building AI, as you let us off with, is the data you have access to and training that data. in so many legal questions around the training of AI with data that may or may not be publicly available, from a legal perspective, is being built and decided right now in courts, oftentimes in the United States. And so I'd love to rapid fire with you a little bit and just kind of talk about some of the big court cases of the day for you, just to talk in general terms. Cause like we said, these might have, changed by the time this gets published, but just talk in general terms about kind of the importance and the impact of some of these cases, if that's something you're up for.
I'm up for it. And like you said, a lot of these cases, first off, there's so many, it's hard to keep up. We do make the best effort. And a lot of them, the underlying claims are the same, right? They're just going after a different AI company. But yes, we can definitely talk about it in a rapid fire style.
Well, let's start off with the New York Times case, which I think is one that a lot of folks have talked about, and is really interesting around kind of the value of pirated works. But
the New York Times case was so critical because it was one of the first. It happened. I don't know I can't recall right now the date of the filing, but it happened very quickly after OpenAI was released and folks were using it. And then it's the New York Times, like major publication, longstanding age publication. Everyone knows it. And here they are going after this new company that has this new shiny toy that everyone loves. What's this about? So the New York Times filed a claim against OpenAI and I believe Microsoft. And the claim is that these companies use millions of New York Times articles to train their AI models without consent, right? They did it without permission. And as far as damages, they were alleging that, again, the output from ChatGPT, for example, it was a mirror image in a lot of cases of a New York Times article. So it competes with New York Times content. You're using my content without consent. You're creating a competing product. So now, as I referenced before, if folks can just go to free ChatGPT, type in something and get what they would otherwise have to subscribe to the New York Times to get, it creates a competing product that undercuts the New York Times, because again, yours is free and mine is subscription based. So that was an early case that everyone was watching. Currently, I'm not sure whether it has not settled and there has not been a final verdict. I believe they're still in the discovery phase. But that's definitely one to watch because, again, it's a huge publisher. AI, in order for AI to function and operate, there are three things that they need. They need massive computing power, they need massive data sets, and they need a human in the loop, whether that's a software designer, engineer, whoever, right? So these companies, they have the human in the loop, they have their engineers, they have the computing power, they're building a lot of compute. They just need the data. And like I said, they've scraped everything on the internet. So with the New York Times, for example, it throws in the additional kind of finger in the eye of how are you getting our content if it's behind a firewall, right? So there's the question of how are you getting this firewalled content? It's bad enough you're scraping everything, but how are you getting my paid subscription-based content? So there's a lot of questions around that. And again, I believe it's still in the discovery phase, so we don't have a final verdict, but it's definitely a case to watch. And many people have been watching it from the start, myself included.
That's really interesting. I mean, moving forward, there's the Anthropic case, which is of course connected to Amazon, who's building so many data centers right now. As you said, they need that, that other piece in that kind of three-legged stool. But can we talk a little bit about the Anthropic case?
Yes. So the Anthropic case, otherwise known as the Bart's the Anthropic case, this was a lawsuit brought by a group of authors who are alleging that Anthropic, who is the maker of Claude, the Claude LLM, you have ChatGPT of Claude. Claude is a front runner, neck and neck with ChatGPT in my view. Claude's a little bit better. But anyway, the allegation is that the Anthropic used the books, the articles, the whatever, the content of these authors to train Claude. And, by using their content without compensating them, Claude is now this fantastic model that lots of people use for lots of reasons, but you've not compensated these authors. That's the allegation there, right? So recently there was a settlement, and it is significant. It is I think it's been approved at this point. $1.5 billion class action settlement for these authors, right? Significant, obviously, because we've one, we've not had a settlement in any of these AI cases that is as significant, and the sheer numerical value, 1.5 billion. And within the documents, a few things happen. So one, we finally have a ruling on the issue of fair use. So fair use is a shield, not a sword, in my view. It is a defense. It's something used in litigation to say, in copyright litigation, to say, well, no. Yes, I used your work, but it's fair use. So I can do it without seeking your explicit permission, because the rights around copyright is, as soon as I take an idea or something, basically I take it and I make it into something tangible, right? I have an idea for a play. I put words to paper. Now I have something tangible. I own the copyright in that, right? This is my creative expression in tangible form. Once you have that, you own the copyright. Let's say you publish it. People have to ask you in order to use anything more than an excerpt, or anything more that, again, an expert for like the in a newsworthy excerpt, or something that they're using for critical analysis. Anything more than that, you need my permission, because this is my work, right? So fair use is a defense that's used a lot to say, well, no. It is something critical. I was referencing this in a scholarly way, in a newsworthy way. People dance around that a lot. So the line as to what is fair use has always been very, very murky.
And they keep pushing the boundaries of how much of it can be used for that purpose.
Absolutely.
And I watch lots of music videos or music analysis videos on YouTube where they're like, if they go 2 seconds longer, they're sure they're going to get sued.
Yeah. And they're going to get that copyright strike, right? So, and we can understand the footing on both sides. As a creative, you're saying, hey, you're taking my work. Like, this is my thing and has a value, obviously, because you want it. Like, it's valuable to you. So pay me. And then on, the other side, for folks who want to be able to freely use these creative things, in a way, they want to say, hey, well, no, I need to reference this for a broader purpose, right? For a scholarly purpose, for et cetera. So this is a case in which fair use, the concept of fair use was actually opined on, right? So the court said Anthropic's practice of taking books and digitizing them and then using that to train their model was transformative enough for it to be fair use. So we've not had a ruling like that. So it's like, oh, you can buy a book, digitize it, train your LLM, and then that's fair use. That's significant. And we've not seen that kind of ruling before. So that's one thing that happened. However, the court did say for books or things that they did not purchase, but that were pirated, because they did get pirated things from like pirating lawsuits, there's a question as to whether or not that's fair use, and it's likely infringement. But then they settled before that matter, that very discrete matter, could go to trial. So we still don't have a clear answer on that. But yeah, again, back to the $1.5 billion settlement. In the settlement docs, there is now, something that could potentially be used as a benchmark to value a work that's been used, which is $3,000, right? So they're saying $3,000 per work. So folks are using that kind of as a baseline of, okay, if I find out that my work was used by any of these companies, I can lean on this and say it's worth at least, right, $3,000 per work, because that's what happened in that settlement. So could be worth more here, but it's worth at least $3,000. That's an argument that can be made.
And that can create a great foundation for settlement negotiations going forward.
Absolutely.
A lot of these things.
The demand letter. And
go around.
Mm-hmm.
Yeah, because they know they've got enough of a leg to stand on. You need to deal with me. Let's actually, find some sort of reasonable settlement.
Yes.
Well, that's fascinating. Can we talk a little bit about the Ross case?
So the Ross case is significant because it's going to be something that's very familiar to a lot of lawyers, right? So Thomson Reuters, which owns Westlaw, which is, of course, a legal research platform that lawyers are familiar with. We use it in law school, use it throughout our practice. They were approached by a third party who wanted to license their content to train an LLM model. Thomson Reuters said no. And then it is alleged that this third party then went through another party to, in a roundabout way, get that information, right? So it's information that they wanted to license. They got told no, but they got it anyway, right? And in essence, what Thomson Reuters is alleging is that the outputs from this, so the third party was developing and training an LLM model. And Thomson Reuters alleged that the this tool that they were creating, again, similar to New York Times, is competing now with Westlaw and with other legal research tools. So again, I told you, no, you can't have my content. You got it in a roundabout way. And now you're creating a product that is competing with me. And as lawyers know, there's a subscription fee for Thomson Reuters product that is significant. So essentially, we're going to ding you. We're going to go after you for creating competing products. And in that case, it was my understanding that it was found to be a lot of the outputs were mirror images of the Thomson Reuters products and like the headings and the abstracts. So it was pretty clear that this company, and even though they went about it in a very roundabout way, was infringing on Thomson Reuters. So it was a significant victory for that company.
So full disclosure, I spent a good chunk of my career at Thomson Reuters. Nothing I'm about to say has anything to do with that. But there's a long history of, Thomson Reuters engaged in various kinds of IP matters around the keynotes, the head notes rather, the key number system, the abstracts, the work that they've done around case law that is, of course, public domain, and figuring out where those lines are. What I find interesting here as we look forward is we look at AI summaries of public domain information, of information that needs to be available to everyone, like case law, like regulatory data. There's some interesting implications for IP of you create a prompt, you create new summaries, abstracts, extrapolations, determinations of what regulations are, of what case law says. Who owns that output? And is that ownable? Is that sufficiently novel? Can you actually get a copyright on that?
Yeah, so that is the question of the day, right? So, of course, AI comes out, you can use AI to write a book. And we've seen folks immediately create various novels, graphic novels, etc., and then run to the the copyright office to attempt to obtain a copyright registration. And the Copyright Office, so the copyright law in this country, it's very old. It's not changed in a very long time. But it's also, in my view and the view of many, it was not prepared for this type of technology because it essentially wants to upend a lot of the grounded laws of copyright. So a few years ago, the Copyright Office sent out basically a call for practitioners, authors, anyone being impacted by AI to kind of submit their inquiries and, tell us about how they would be impacted by AI, et cetera. And from there, the hope was that they would, figure out if they needed to adjust the long-standing copyright rules. So let's fast forward and, provide an answer to your question. An output that is purely the effort, I would say, or purely generated by AI is not copyrightable. You cannot insert a prompt, get an output, and then attempt to copyright that output. There is a human authorship requirement for all copyrights. And even though you're inserting a prompt, that's where your human authorship essentially ended, right? You're not responsible for the output. However, let's shift it to the next phase of that. Human AI collaboration, right? You as the human, you insert a prompt, you get an output, and then you transform that output. You put your own spin on it. You reframe it. You revise it, right? You use the output or iterations of an output as a baseline, a general start, but you incorporate your own style, your own editing, your own formatting, your different components. And now you have a true output that is some parts AI, fully AI generated, a lot of parts you. You can then seek to go to the Copyright Office to get a registration for that work. However, you're only going to get a copyright that you own for the parts that you created. So, for example, there is a Zara of the Dawn. There was a graphic novel that an author created using AI. And they wanted to get, I think it was the Zara of the Dawn case. They wanted to get a registration for it. And whether it was that case or not, the office ultimately said, well, the portions of it that were written strictly by AI, or these images that were strictly AI, you cannot own that. But these images that you may have generated and then you tweaked, or the portions of the text that were generated but then you updated, you can get a copyright registration for those portions that you transformed as a human. You had a human authorship element in those portions. But something strictly generated by AI, you cannot own the copyright.
Well, the factual implications of all of those
Case
determinations are
by
so
case.
intensive. Within patent law, there's the ability for it to evolve with changing technology, like patent law that applied to analog technology pretty much stayed in step in the framework of it as we moved into digital technology through equivalency. Copyright is I think struggles a little more with that as we move forward, as we get into this AI generated world. It's such a fine line between something that is human generated and something that is AI generated. And the more we merge those two, as you say, we're going to get to a point where that's going to be a very hard thing for the law to address as it is currently structured.
I've got one thing better, right? So I'm a realist in a lot of ways, right? When you, as someone, goes to any institution, it's kind of like the pains and penalties of perjury. You're saying that this is true. You're saying that this is accurate. We know that AI is trained on human authored works, which is why like AI detectors generally don't work. Like it's trained on human authorship. So, M dashes be darned, like people write with M dashes, right? So it's very.
I'm a big fan of M dashes. It bothers me that that's now scrutinized.
Exactly, right? So it's a tall task to say that text. They ran the Declaration of Independence and they said it was AI generated, right? They ran that through a model, right? So
I did not see that.
Yeah. So the moral of the story is those detection tools, too, in my opinion, I don't, even so OpenAI even had their own tool that they had to sunset because of its low rate of accuracy, right? I was just chatting with someone around that. So starting there, it's very hard to detect AI generated text, one. So two, if someone did use a model to generate something, when they go to the Copyright Office, you kind of have to tell on yourself, right? You have to say, well, yes, I did use AI. For unscrupulous folks who would just want to get the copyrights, who's going to check them and say, well, no, this is AI generated? Like, how do you detect that? So a lot of it is on, Scout's honor. This is true. This is my portion. This is AI's portion. And wanting folks to, hoping that folks are being truthful. That's where we stand now. However, I will say that there's a push and there's a litigation right now where someone's trying to appeal that whole human authorship versus, human, where it's like, well, I crafted this very strong prompt and that's what gave me the output. So this is my human authorship. Like without this prompt, I wouldn't have gotten that output. So it's still being battle tested, but that's where we are now as far as the, you need the human authorship component, which you've always needed for copyrights, but that could change, right? It's being battle tested now, as are all of these things.
And, just closing out the case conversation, because as you said, a lot of these cases are around similar things with folks kind of alleging similar things. But, I know the Meta case is one that everyone uses, Facebook, Instagram, et cetera, that, folks may know about. And then also, the recent suit of Reddit suing Perplexity AI. If there are any kind of, points in those suits that you think, are worth kind of bringing up for folks interested in these kinds of cases, would love to have you speak a little bit about them.
Yeah. So quickly, the Meta case, and this signals something that's troubling, which is two courts with seemingly identical cases ruling very differently, right? So for the Anthropic case, the authors essentially though it was by settlement, it was alleged, the authors run out. I'll just shift to Meta. So in the Meta case, a group of artists and authors like Sarah Silverman, Ta-Nehisi Coates, they alleged that Meta used their copyrighted books without permission to train their large language model, which is Llama. And they alleged that, it was competing with their works for the same reason I've mentioned, which is, someone can get my output from Llama instead of having to come to me to purchase the book, et cetera, that type of argument. And in that case, the court sided with Meta. They said that the artist didn't show enough, what was the term? Market harm. And that, they did not show that this LLM and the fact that it may have been trained on their content somehow undercuts their books, their works. So again, we're having this patchwork effect where courts in different circuits or different places, they're ruling differently. And granted, there's different lawyers. So the way they presented their cases, even though it might be similar, maybe it's not as strong. We don't know, right? So, these are just recent, and they're not settlements, right? This was just like, it's still litigation. It's just like the court granted a partial motion for summary judgment. So there's still a full case ahead for other points. So I think the moral of that is we're going to watch it. In my newsletter, I just presented, it was a snapshot of how many copyright related AI cases are in queue. And I think it's something like 251. There's a lot of them, right? And outside of what we've spoken about, you have cases about, image, the Getty case is a big one where, they're saying, you're training on all these images and, photographers, photography and the like. So we have a patchwork of cases that deal with the arts. Love the arts, right? Written content, images and the like. And I think in 2026, because a lot of these cases are going through, the litigation stages, we should have some either significant, hopefully some significant settlements or even judgments, so we can get an understanding of what the courts think about these very important topics.
Speaking of very important topics, there's something I want to ask you about that came up in the newsletter recently. One of the things you just covered that I found really intriguing was how AI can help level the playing field for access to legal services. And you wrote about a story of a pro se litigant who succeeded in her matter. Can you tell us a bit about that?
I find it fascinating, and thank you for asking that question. So again, back to that spectrum, some people who are just so anti-AI and then people who are truly leaning in. So the case that I covered, I believe it was out of Florida, it was a woman who was being, I think, sued by her. I'm not sure if she owned like a trailer, whatever it was. She was being sued by her landlord for fees, etc. And I believe she didn't have the resources to get a lawyer, or maybe she did. However, the moral of that story is she ended up subscribing to an AI platform and used that as essentially her counsel, right? So she typed in different prompts and got a lot of information about different resources, how to structure her arguments that failed in the past, but arguments that might be successful for her specific case. And she went into court with those arguments, with those links to different resources, and ended up winning, right? So she won significantly. And from her purview, as she was interviewed, she said it was like having God on her side, right? Because when you think about think about the traditional legal landscape, she would have to go out, find a lawyer, likely pay a hefty retainer for them to engage with her, right? Because for that type of matter, I don't know that folks are taking on contingency, right? So she'd have to come up with a couple thousand to have just a lawyer review her case and then sit with her, and then more money to structure, and then more money to go to trial. Instead, what she did was she went to, and I can't remember what platform she used, but most of them are like $20 a month for unlimited responses, right? Unlimited resources, unlimited outputs around strategy and, tweaking your strategy nonstop. So AI, a lot of people say, and it's true, it's like having a very smart intern, right? Someone who doesn't need sleep, someone who can constantly give you information. You could iterate all night long, right? She could have sat there all night and worked on her case, and it cost her $20 per month. Whereas that same time, energy, and effort with a lawyer, it would have been thousands. So she definitely mentioned that, and she was thankful that she had this resource that ultimately ended up being successful for her. Now, with all things, there's a caveat, right? AI is prone to hallucination. AI is not a lawyer, cannot be a lawyer because it's not a person, it's not past the bar, even though they've had some testing around whether AI can pass the bar. But it is a repository of helpful information. And for people, there's an access to justice element, because for people who don't know a lawyer, can't get to a lawyer's office, and, even if you can, you don't have the funds to pay for a lawyer, it can be helpful, as in her case, to have this tool that can give you information you otherwise would not have had. Now, it can go very, very wrong, right? And I anticipate that we'll see folks using AI and getting it very, very wrong. But in her case, it went well. And, it was one that was marqueed and heralded as, look what AI can do. And it's coming for your job, lawyers. I don't think we're quite there yet. But it can be helpful, is the moral of that story.
Yeah, because there's such a need for that access. And I mean, over the years, we've seen Rocket Lawyer, LegalZoom, Nolo Press, and, a whole bunch of others try to create that technological access to the basic foundational legal information that you need to start a business, defend your rights, etc. But there's no conversational experience there. There's no back and forth. And this creates such an exciting opportunity, I think, to engage with that wealth of information that you need in a cost-effective way that can scale.
There's absolutely that. But again, the educational piece, right? Folks don't know that AI is sycophantic. It's going to tell you every idea that you've input is the greatest idea. And yes, you're right with this strategy, right? So there's also the piece around knowing how to ask the question so you get like the most clear, concise, direct, and accurate answer, and not just the fangirl episode, right? So education is always going to be required, in my view.
I'm just curious to see if we see a chatbot emerge that's basically going to be like, what? No, that argument will never fly in front of a judge.
I think someone
really?
should create it. There
You're
are
going to go into court and say that? I'm embarrassed for you.
There are
You know,
industries
and
where
then-
people go to get like that type of honesty or like directness. So why not a chatbot? $1 million idea.
Maybe it could, you could certainly train a chatbot to be that blunt with people, and then they might go, sounds like a lawyer.
Agree.
On the other end of, that example of AI helping kind of the smallest of defendants, a recent newsletter also mentioned the fact that you're seeing big law actually advancing faster on AI adoption than smaller firms. I'm wondering if you're still seeing that and why you might think that would be the case.
Yes. So that was based on a recent study that came out that I'm still digging through, but that was the essential takeaway, right? And I think that's the takeaway for a few reasons. One, larger law firms have more resources. So it's almost nothing to say, okay, it's been a few years, AI is here to stay. We have a lot of like legal AI tools. Let's invest. Let's see if it works. Let's get some consultants in. Let's train, right? So that's a hardy investment. If you are a multinational firm and you're doing that across the board, it's going to be a hardy investment. Smaller solo firms or, regional firms, they may not have the budgeting for that. So I think the discrepancy that we're seeing is a matter of resources, because smaller firms may be using ChatGPT, right? They may be using it at the free level, but perhaps they don't have the monetary investment that then shows up in these studies as being like this deep, leaning into AI. What I will say is that for folks that I know, and I used to work in big law, I used to work in big law, I used to work for a regional firm. The folks that I'm talking to in big law, like, yeah, there's like an AI session every Wednesday, but are people actually going? Are people actually like implementing the thing? And it may be that they're not, because I found, and this was one of the reasons I was hesitant about even focusing on lawyers. We're so risk averse that even with this, that you can do all the training, you can do all of the information, there's still a hesitancy. Whereas you don't find that in industry with like, creatives or authors. They just want to get to the output, right? But lawyers, because of who we are, how we've been trained, the fact that we have a license on the line, we're going to be very, very hesitant to put anything into a model that we know can expose client data, right? Even if it's sanitized, you've removed all the information, you're still going to be very, very weary to use the tool. We've seen lawyers who, perhaps their firms have invested in, so there are a lot of contract review and redlining AI tools, right? That the promise is they're going to cut, they're going to cut, the review time. And what studies have shown is that lawyers still go and they read line for line every edit, like line for line every red line. So it's almost, I'm not going to say double the work, but is the efficiency truly there if you're going to take the output and then go line for line? There's not a lot of confidence yet in the legal space, I think, as it relates to AI. And that may build over time where, you're confident in an output and you just kind of skim it and say, hey, this is good. But for right now, we don't have that. I was recently at on a panel and I mentioned that, for a lot of firms, you have your tried and true templates, right? They've been vetted by the partners. They've been vetted by you, the senior counsel. So you can start with that template, and you're going to be confident, or I just need to add this section, it's good to go. You're not going to have that same confidence in AI because it hallucinates, hasn't been vetted by your firm. You're just going to be way more critical of the output. So you end up in this state of like, there's no true efficiency because, again, you're going line for line.
I think a lot of that comes because it's a very real concern. I think a lot of that comes down to this very essential difference between closed environment analysis and a GPT-like experience that goes out to the breadth of the internet and says, that's not how you should word this clause. That's risky.
Absolutely.
Very different animals. If you're using AI to compare your draft against your template, it can, I think there's a higher degree of confidence in what that's delivering back. But that distinction is not always well understood. It's a chatbot. I'm asking it a question. What's the difference between this one, that one, and that one?
So because I'm kind of in this space, it sounds like you're talking about RAG, Retrieval-Augmented Generation. So you can have like a closed network where it's pulling just from your content, comparing just against your content. And that's more secure because it's a smaller corpus. It's not just the broad internet, right? So, I work with folks who want to implement a RAG system. And, over time, as you're using it, I don't even think it's the content. It's the use of the tool, right? There's just an apprehension to use any tool. But with RAG specifically, when you're using it against, and it's pulling from your corpus, your documents, your templates, and then you're getting an output that looks, basically, very similar to what your company would otherwise produce, it builds confidence over time. And I think more people lean in and use the tool when they see that.
Awesome. Well, Kimberley, it's been such a pleasure having you speak with us today. We might have you bring you back in the new year just to get updates on, that landscape that we touched upon today. But thank you so much for sharing your knowledge and wisdom with everyone.
Thank you for having me. I think the time flew by and I was a little nervous, but I think I did pretty okay. So hopefully everyone finds this informative, and I would love to be back anytime you'll have me. Thank you both.
Thanks so much. Great to meet you.
Meeting of the Minds, the Legal AI podcast, is brought to you by Eversort. To learn more about Eversort and how we can help you contract better with AI, visit Eversort, EVISORT.com.
You can find Meeting of the Minds on Apple Podcasts, Spotify, or wherever else you listen to podcasts. Don't forget to click subscribe so you won't miss future episodes.
On behalf of everyone here at Eversort, thanks for tuning in.